I'm Daniel Malakauskas of Malakauskas Law, an immigration law firm, and today I'll be giving an introduction to U.S. citizenship through naturalization. What is U.S. citizenship through naturalization? U.S. citizenship through naturalization is the process that a U.S. permanent resident becomes a United States citizen. It is often the end goal of immigrants that move to the United States. It is a long process, but ultimately leads to the permanent right to live and enjoy all the privileges of the United States. What is the difference between U.S. citizenship through naturalization and a certification of citizenship? U.S. citizenship through naturalization is the process that an immigrant who does not have any birth or blood right path to citizenship must take to acquire United States citizenship. U.S. citizenship through naturalization does not apply to the children of U.S. citizens that were born abroad. The process of obtaining citizenship through bloodline is known as obtaining a certificate of citizenship or a U.S. consular report of birth abroad. What are the requirements for naturalization? You must meet the requirements of 8 U.S. Code 1427 to qualify for citizenship through naturalization. In plain English, to qualify for U.S. citizenship through naturalization, there are two main requirements. Number one, you must have been a continuous permanent resident and been physically present within the United States for a certain amount of time. And two, you must not have a serious criminal record or engaged in other acts deemed disqualifying by the United States. Your residency requirements listed in more detail are: number one, you must be a lawfully admitted permanent resident. And two, you must have resided inside the United States continuously for 5 years before filing your application. Number three, at least half of your time as a resident, you must have been physically present inside the United States. And number four, you must have resided in the state where you file your application for at least 3 months. And finally, 5, you must continue to reside inside the United States until your application is approved. Your moral character requirements in more detail are: number one, you must not have a serious criminal record. Number two, you must not have engaged in certain disqualifying activities. The list of potential disqualifying activities is actually a very long list. However, most disqualifying activities are common sense. When evaluating your moral character, the United States Citizen and Immigration Service may investigate actions you may have engaged in well before your 5-year permanent residency. In addition, simply because you cannot be deported does not mean you will necessarily qualify for citizenship. What documents are required for U.S. citizenship through naturalization? The supporting documents you will need for your application depend upon your specific situation. However, common supporting documents often include, but are not limited to, the application for naturalization, known as Form N-400, copies of your permanent resident card, passport photographs, financial records, tax records, criminal records. However, not all of these documents will be required for every application. In addition, your circumstances may require different or additional documentation. How do I start the naturalization process? You start the naturalization process by filing an application with United States Citizens and Immigration Service. The application is entitled Application for Naturalization. The application requires supporting documentation and may require additional forms depending upon the facts of your specific situation. The paper version of the application for naturalization is known as Form N-400. 400. What happens after I file the application for U.S. citizenship through naturalization? After you file your application, the United States Citizens and Immigration Service will schedule for you to attend an interview, or in the alternative, it may request additional documentation for your application. If you obtain a scheduled interview, you should begin preparing for it. If you receive a request for additional information, you should promptly obtain any required documentation. The interview will also consist of a civics examination and an English proficiency examination. Does U.S. citizenship through naturalization require English proficiency? Yes. In order to obtain U.S. citizenship through naturalization, you'll be required to read, write, and speak basic English. According to 8 CFR 312, no person shall be naturalized as a citizen of the United States upon his or her application unless that person can demonstrate an understanding of the English language, including an ability to read, write, and speak words ordinarily used in the English language. What this means for naturalization is that you are required to be able to read, write, and speak basic English. As part of the process, you will be required to read and write 1 out of 3 sentences correctly. Applicants should take learning English seriously, as a common cause of denial of their citizenship is due to a lack of ability to read, write, and speak English. Does U.S. citizenship through naturalization require a civics exam? Yes. You will be required to take a civics test. Which civics test you take depends upon when you filed your application. If you filed your application on or after October 20th, 2025, you will take the 2025 Naturalization Civics Exam. The 2025 Naturalization Civics Exam is an oral test that consists of 20 questions. The 20 questions are chosen from a list of 128 questions. You must answer 12 of the 20 questions correctly to pass. What happens after your U.S. citizenship through naturalization interview? After you have attended your interview, United States Citizens and Immigration Service should issue a decision within 120 days. However, the government is prone to delays and it may take longer to receive your decision. What happens if your U.S. citizenship through naturalization application is denied? If your naturalization application is denied, you may request for a hearing on that decision. In order to request a hearing, you must file the document entitled Request for a Hearing on a Decision in Naturalization Proceedings under Section 336, also known as Form N-336. The document must be filed within 30 days from you receiving your decision, or within 33 days if the decision was mailed to you. After filing your request, a new interview will generally be rescheduled within 180 days. You will be required to submit supporting evidence to address the reason for your initial denial. Should your application be denied yet again, you are allowed to file an appeal in federal district court. If you enjoyed this video, please like. If you have any immigration questions, feel free to leave a comment. Thank you.